down to the jail that day and posts the $100,000 bond, and then within 5 days, he's alleged to have committed a new offense. A man who has a criminal history, who's out on bond, who just recently got out on an increased bond, is alleged to have committed a new offense, and it shows a danger to the community, not only.
What are we doing?
I was.
You're Nathaniel Clark?
Yes. I was a court appointed attorney. I was just informed that he has retained counsel, so I'm going to step back and turn it over to.
And you or Mr. Manning?
Yes, sure.
Okay. So let's see. You're charged with, you're Nathaniel Clark.
Yes, sir.
Do you understand you've been indicted, and this was 7 months ago, for the third-degree felony of operating a motor vehicle in a public place while intoxicated? You have, though, that's not the worst part of it. You got prior convictions.
Yeah.
Don't interrupt me. When I'm through, you have a fair opportunity. Okay. There's, according to the grand jury, in 1997, you were convicted of illegal possession of marijuana out of Wichita Parish, Louisiana. My family's from. Then the third paragraph goes on to allege that after that felony of illegal possession of marijuana was finalized, you committed the offense of aggravated battery and were convicted in Wichita Parish, the same fourth judicial district court, of that offense of aggravated battery in 99. So if you are convicted of this third-degree felony of operating a motor vehicle in a public place, and if these two other priors are indeed valid, then you're looking at no less than 25 years imprisonment to life in prison. Do you understand what you're facing according to this indictment? Yes or no?
Yes.
Okay. As long as you know that. And also, you're not eligible for probation for this office. So what are we going to do?
I'm sorry, go ahead.
Oh, yeah.
I'm just going to look at the situation.
Yeah, well, that's what happens when I was defense attorney a long time. So those things fall in your lap, but I don't wait around. I move forward, especially when it was indicted last year.
Right. So legally, we're working with under discovery.
What is that? Okay, it's 7 years. What happened to the guy before? He was representing him.
John West.
Well, John, you had him for 7 months. Did you pass all the information to Mr.?
No, I had him for 7 months. He's been fine. I wasn't appointed that. I'm not sure when I got appointed. I was appointed recently. I've only had one court date here.
And at that court date, Mr. Clark did not appear. He had a failure to appear, and you increased his bond to $100,000.
You were the attorney in January, as of January, and there was an initial docket. It was reset until February, and then that was reset until March. Yeah. Then that was reset until May, and then that was reset until later in May, and then that one was reset to, I think, today. Yeah. So what is that, 5 resetting? Bad gum. Come on.
Yes.
All right.
I don't know if off the top of my head, Your Honor, I can't.
Have you related things to your prior counsel as far as the office?
Yeah. A lot of it. Yeah, that was, we did.
Well, we didn't get a chance to get to that. So it's 4 versus 4.
What are y'all going to do? What are you going to do?
Well, I have concerns with Mr. Clark because he failed to appear. You increased his bond to $100,000. He posts the bond the next day. He gets out and he's alleged to have committed a new assault, family violence.
I'm not aware of that.
I filed a motion to increase his bond, and that is actually what this is set for this morning.
Okay. Okay, I'm looking at it.
Yes, sir.
And what happens, you tip me off ahead of time.
I apologize.
That's okay. This was filed on the 9th, but when it goes into the file, I don't see it until I break open the file of the docket. This states this accuses a family, an injury to a family member in 26 CR 1567. Can you pull that for me?
That's 08766. Sorry, what did you need, sir?
So you tell me.
26 CR 1567.
If you're interested about the PC, Judge, I have that from the,
I just want to know, I want to look at when that got filed and
it was filed on June 5th. The offense occurred on June 3rd.
I can go.
why did we increase his bond?
We increased his bond because he didn't appear in court properly on May 27th.
Did you know?
And the next day he goes down to, actually he goes down to the jail that day and posts the $100,000 bond. And then within 5 days, he's alleged to have committed a new offense.
Did you let me back to see it?
Why would I know that, sir?
No, so they did counsel like anybody had to you now.
Again, why would I know that?
Right.
I thought you were clairvoyant.
I've been told a lot of things. That's not one of them. No, sir.
First name has not been known as Claire.
No, sir.
Well, that's what he just related to hear. There's issues here. Moving with another court.
I don't care. What I care is that he was out on bond and commits a new offense.
Well, no, I'm saying as far as it looked successful, the failure to appeal.
Sometimes it's
Sorry, Judge.
Sometimes it's amusing.
He
just
keeps,
listening.
he keeps visiting with me instead of
He's
going.
learning. He's trying
Yes,
to
sir.
figure it out.
Yes, sir.
I was defense attorney for a long time, and things always surprised me. I was the last to know a lot of information about my client.
Well, now, as far as that goes, Judge, he has taken the original step to go through the portal to get discovery. I've seen the initial email and the response from the district clerks, but that has not been cleared. He's going to have to get with the clerk's office because he's new to the system. And so he has not had access to the
Okay, so
Okay.
we don't have their files, nor can I have access to it like theirs. If Mr. Hamp has the PC, that might be the only way. we can get
You
it.
have the information.
at the PC here.
No,
And I can print you out that, Judge.
Thank you.
Yes, sir. Give me one moment, Judge.
Still very Sean Villar, Hamilton. Thought my boss and your boss talked about this, and I go, but don't move, so I'm just gonna go do things and look down right here. Yeah, didn't trickle down very last so he said it all, but I don't know anything about his house. If I didn't, somebody would say,
We have a copy of this.
I hadn't seen it.
Okay, we'll make a copy.
it's gone. It's no dog, it's a, okay, cool.
Did you still know? Is the original, was the original for only 10,000?
Yeah, it's not-
Is that correct?
Yes.
I'm curious, was there any analysis suggest why they go from 10 to 100?
Didn't appear in court.
Typically, they don't show. Is that a typical case?
That was his decision, not mine.
It's always my decision. There's no litmus test except for the circumstances of the situation. The thing was, I felt that was,
It's a little grab that I don't know if I didn't see it.
when did he, when was the bond? increase?
May 27th, 2026.
Yeah, it was because, it was, a date for a plea. According to the attorney, and he failed to appear. Thank you. Oh, it's not for him. Thank you. It's wonderful. With the things. That's why that bounced up.
That's why it's important is to.
There's always a reason. It's just a matter of figuring out what it is. Generally, I double it, but if there are other circumstances, and that's, I rely on representation from the attorney and the defendant, and then if they don't, you know, they can always change their mind, but they need to be present.
Yeah, obviously not.
You want anything else from that misdemeanor file? Do you want anything else from the misdemeanor file?
Good pleading, unintended case.
All right. Okay, Mr. Manning, what are you gonna do with that? From the defense side.
As far as today, I actually was going to make my request, he's going to have to tax, why, because if you can come back to Monroe and move back with his family,
Sir?
if he can come back to Monroe and actually have his home confined in Monroe.
What am I, why?
You entered a condition on his bond of home confinement after his failure to appear on May
Whatever,
27th.
well, he's on home confinement, whatever his home is.
His home is here. His home is here, Judge.
Yes, so if it's here, but I mean, if he moves to another home, that's okay with me. But it would be home confinement. But here's the problem is that I've got this motion now for an increase in bond, and I've got the information that's been filed that alleges a misdemeanor of assault on a family member, which is never. It's serious because if you're going to assault a family member, what are you going to do to someone that you don't know? And hold on, and this occurred on or about June 3rd, is what this alleges. And this was filed on June 3rd. And what had happened was, unbeknownst to me, a week later, the defendant was here on June 10th. Right?
Not to my knowledge.
2 weeks ago?
Not to my knowledge.
Well, since I've got 5,000 cases, I have to see on that date, it was set for that. And that was reset.
That's a notice based upon the motion I filed. It wasn't his appearance, Judge.
This case is reset on the hearing. Okay. On 6/10, when this case is reset for a hearing on 6/24.
They actually set.
He was here on 5/29.
He was not here on 5/27. He gets out on the new bond, alleged to have committed a new offense. I filed a motion to increase his bail on June 9th. The court on June 10th set it for a hearing today on that motion to increase. The logistics are, he now has a new lawyer who hasn't had any access to the discovery.
Well, we still, notwithstanding that,
Yes,
we're going to take up the matter of a bond.
Yes, sir.
All right, what are we going to do today, gentlemen, on the motion to increase the bond?
In our position, the $100,000 bond, that was significant bond in this situation. You're reading about what his wife, they're going through a divorce. And these are just these allegations that she made, suggesting that she was injured with a wrist injury. I hadn't seen the medical records to support that, not saying that, anything didn't occur, but she's claiming that significant or some injury occurred. I believe that the $100,000 bond is, and also he's in a position where he wants to live at home, yet he's now filing for divorce to get away from her. So I don't know if that's going to be an issue. I know situations with her in the last 10. She's in a situation where she's basically trying to hurt him, with him not want to be with her.
What's that say?
Oh, no, like it.
This has been looked at by our office. I've actually talked to this complaining witness. The probable cause sets out the facts there. We've determined that there's more than sufficient evidence to move forward with the accusation. And the problem that we've got here is a man who has a criminal history, who's out on bond, who just recently got out on an increased bond, is alleged to have committed a new offense, and it shows a danger to the community, not only to Ms. Clark, but to anybody else. The theory that there may have been some divorce filed is insignificant compared to what the accusation. The bond needs to be addressed. $100,000 is not sufficient. It needs to be increased at a minimum.
Oh, Mr. Manning, what do you ask? We kind of knew that all of it, but sometimes you get thrown into the game when you're warming up.
I believe that even with the $100,000 bond with him missing court, I believe it's custody under central discretion. So, but if he went from 10, I believe it was originally 7, and it went to 10.
There's no,
And then it went to 100. So
because that was the third time we had to increase it, right?
Well, I think
Judge, not to interrupt Mr. Manning, but I believe the whole reason why you increased it is you felt like 10 was insufficient based upon his criminal record. And then with him not showing, it just made matters worse. And that's why you entered the amount, Judge.
What bothers me too is he's got an aggravated battery conviction, assaulted. It's assaulted of nature. And here we are on my watch when I have allowed him out on bond. He's accused. There's a charging instrument now filed with probable cause that states that you committed another assault. Because this dangerousness to the community is enough and probable cause to believe that you've committed a crime is good enough for me to raise your bond again. But and let's don't forget, you're a habitual offender. You've got no room for mistakes, especially assaulting, being accused of assaulting a girl. When I grew up, that was laughable. You don't assault girls, the man. Your bond is increased to $200,000. You understand? And the same conditions will apply. If you get out, you're at home, but you have no contact with any victim of a crime, including this. Then you have to have a GPS device, and you can't leave the house except for food, to see your lawyer, for medical needs in the most direct route possible. Anything else? You raised your hand. What do you want to say?
I'll get accused. Not true, I guess accused.
Probable cause is enough for me to raise your bond, sir. You've the probable cause to believe you've committed another crime. And here's the probable cause affidavit. Your attorney has a copy of it.
Yes.
Thank you, Judge.
Yeah,
He may actually already have he should already actually have the GPS from the prior.
Yes.
and before he leaves, we're gonna, before he's taken in, we're gonna,
Take it back there, I'll get
yeah,
together.
before he's taken to jail, I'm gonna test him to see if he's on any kind of controlled substance.
He's in the proceedings. We want to this happen.
What are you gonna do next, sir?
So we need to reschedule.
Yeah, you don't wanna, is 2 weeks good? Something be done in 2 weeks, you think?
Then I told him first, with the issue. Send me an email. We're gonna lay in. That's probably.
Really? 3 out of Louisiana?
You say you.